had completed his LLB from Gnanaganga University, Gulbarga, and completed his LLM from PG College of Law, Osmania University. His lordship was also awarded PhD from University College of Law in February 2023. His lordships got enrolled as an advocate in July 1987 and thereafter got appointed as junior civil judge and was later promoted as senior civil judge and again got promoted as district judge. His lordship was later appointed as Registrar Judicial for High Court of Judicature at Hyderabad. On 2nd March 2017, then his lordship was appointed as first Registrar General for State of Telangana on 1st January 2019. His lordship was elevated as Hon'ble Judge of for State of Telangana on 15/10/2021. We thank his lordship for accepting our invitation to judge the Moot Court competition. With your permission, we'll start the proceedings, your lordships.
The council seeks permission to collectively address the bench as your lordship. Much obliged, your lordship. Lordship, for the we the council from the side petitioner, I would be dealing, the council one would be dealing with the first and the second issues, and my co-counsel would be dealing with the third and fourth issues. If your lordships are well versed with the facts of the case, the council would move ahead with the arguments. Indeed, your lordship. Your lordship, in the present case, there are two women who identify themselves as lesbian. One is Nivira, who is a 30-year-old independent woman, and the second one is Diya, and they have been in relationship since 2014. And also they had a wedding cum commitment ceremony in year 2019. But they faced a lot of difficulties after this wedding cum commitment ceremony, in the sense that when they could not adopt a child as both as the parents of the child, and a single mother had to adopt. And coming to the next point, that they were not included in the definition of the couple, because couple's definition just includes legally married men and women in the Surrogacy Act, and also they could not go with the surrogacy method to have a child. And next point, in the insurance, they were not treated as a couple, and they were not given health insurance as husband and wife. And later on also they faced many difficulties because they did not have their marriage certificate, which would be granted to a marriage, and thus they have been denied the right to marry. And also they are excluded from Hindu Marriage Act and Special Marriage Act and other marriage laws, as to they are not included in such acts for the purpose of marriage. And thus the recognition, thus these acts do not recognize them, and thus we hereby plead before this honorable court to pass the judgment in the favor that they should be allowed to marry. If your lordships are satisfied with the facts, the council seeks permission to move ahead with the arguments at once.
Already they are married, and why they need to marry, permission to marry?
Your lordship, they are not married yet. Like they do not have the marriage certificate. They
with the flags they were married. The ceremony, wedding cum commitment ceremony was undergone in January 2019.
Your lordship, it is wedding cum commitment ceremony. It's not marriage. They both are Hindu and they wanted to perform their marriage under the Hindu Marriage Act, and they haven't because the Hindu Marriage Act does not promote or support the marriage between same-sex couple. They are not given the marriage certificate, and thus they were denied the right to marry, because they do not get the bundle of rights which a heterosexual couples get. And thus we hereby contend that their marriage, the marriage cum commitment ceremony, should be considered as a marriage, and that heterosexual and the couple should get all the bundle of rights as a heterosexual couple. They are not yet married.
I understand that only no certificate is given. That's why you are seeking a permission for getting a marriage certificate, but not that when without marriage only they have applied for surrogacy, adoption and everything.
Had completed his LLB from Gnanaganga University, Gulbarga, and completed his LLM from PG College of Law, Osmania University. His lordship was also awarded PhD from University College of Law in February 2023. His lordships got enrolled as an advocate in July 1987 and thereafter got appointed as junior civil judge and was later promoted as senior civil judge and again got promoted as district judge. His lordship was later appointed as Registrar Judicial for High Court of Judicature at Hyderabad. On 2nd March 2017, then his lordship was appointed as first Registrar General for State of Telangana on 1st January 2019. His lordship was elevated as Hon'ble Judge of for State of Telangana on 15/10/2021. We thank his lordship for accepting our invitation to judge the Moot Court competition. With your permission, we'll start the proceedings, your lordships.
Counsel seeks permission to approach the barracks. The council seeks permission to collectively address the bench as your lordship. Much obliged, your lordship. Lordship, for the we the council from the side petitioner, I would be dealing, the council one would be dealing with the first and the second issues, and my co-counsel would be dealing with the third and fourth issues. If your lordships are well versed with the facts of the case, the council would move ahead with the arguments. Indeed, your lordship. Your lordship, in the present case, there are two women who identify themselves as lesbian. One is Nivira, who is a 30-year-old independent woman, and the second one is Diya, and they have been in relationship since 2014. And also they had a wedding cum commitment ceremony in year 2019. But they faced a lot of difficulties after this wedding cum commitment ceremony, in the sense that when they could not adopt a child as both as the parents of the child, and a single mother had to adopt. And coming to the next point, that they were not included in the definition of the couple, because couple's definition just includes legally married men and women in the Surrogacy Act, and also they could not go with the surrogacy method to have a child. And next point, in the insurance, they were not treated as a couple, and they were not given health insurance as husband and wife. And later on, also they faced many difficulties because they did not have their marriage certificate, which would be granted to a marriage, and thus they have been denied the right to marry. And also they are excluded from Hindu Marriage Act and Special Marriage Act and other marriage laws, as to they are not included in such acts for the purpose of marriage, and thus the recognition, thus these acts do not recognize them, and thus we hereby plead before this honorable court to pass the judgment in the favor that they should be allowed to marry. If your lordships are satisfied with the facts, the council seeks permission to move ahead with the arguments at once.
Already they are married. Then why they need to marry, permission to marry?
Your lordship, they are not married yet. Like they do not have the marriage certificate.
As with the facts, they were married. The ceremony, wedding cum commitment ceremony was undergone in January 2016.
Your lordship, it is wedding cum commitment ceremony. It's not marriage. They both are Hindu, and they wanted to perform their marriage under the Hindu Marriage Act, and they haven't because the Hindu Marriage Act does not promote or support the marriage between same-sex couple. They are not given the marriage certificate, and thus they were denied the right to marry, because they do not get the bundle of rights which a heterosexual couples get, and thus we hereby contend that their marriage, the marriage cum commitment ceremony, should be considered as a marriage, and that heterosexual and the couple should get all the bundle of rights as a heterosexual couple. They are not yet married.
I understand that only no certificate is given. That's why you are seeking a permission for getting a marriage certificate, but not that when without marriage only they have applied for surrogacy, adoption and everything.
Income commitment ceremony, they wanted to have a child of their own, and so that they went for adoption and surrogacy method.
Before marriage.
No. After the wedding cum commitment ceremony.
Marriage is already performed, but we were seeking for a certificate, validity of that marriage.
Your Lordship, the validity of that marriage is indeed in challenge, and that the Special Marriage Act and Hindu Marriage Act and the other marriage laws do not recognize them as a married couple. But to them, they had their ceremonies performed as Hindus and they had a wedding, but it was not recognized by the law, and thus we say that the laws are violative of fundamental rights and should be interpreted in a manner that these laws include these LGBTQIA community individuals to be married and have same bundle of rights as a heterosexual married couple. Much obliged. Your Lordship, for the convenience of this honorable court, the council would further divide the first issue into further 4 contentions. The first contention would be that the impugned laws are violative of right to equality, and the second contention would be the impugned laws are violative of Article 14, and the third would be the impugned laws are violative of Article 15(1), and lastly, the impugned laws are violative of Article 21. The council seeks permission to move ahead with the first contention that the impugned laws are violative of right to equality. Much obliged, Your Lordship. Your Lordship, equality is given under the Constitution of Indy under Article 14, which says no person shall be state shall not there should be equal treatment and equal protection of law, and we say that the later part, equal protection of law, to there should be a test of arbitrariness. And for that there should be an intelligible differentia and a rational nexus to the objective sought. But in the present case, a class has been divided amongst the class of the other as a homosexual couples in the ambit of couples, but there is no objective sought as to why have they not included these people in this ambit of section 4 and 5 of Hindu Marriage Act and Special Marriage Act and other marriage laws respectively. And thus we say that it is very arbitrary and unreasonable in nature, and thus is violative of their right to equality, because they are being treated as unequals from the rest of the society, and no reason as to whatever has been given by legislature till now. And thus we contend that this act is very arbitrary in nature and thus is violative, and thus breaches their fundamental right to right of equality. Coming to the Article 14 perspective, that is the second contention, which also means that if you want to discriminate, there should be a positive discrimination, and also there should be a reason why as to they are being discriminated. But in the present case, there is no such reason as to whatsoever they are being discriminated, because what we contend for is love, and not they do not recognize this, and that is why they have made a distinction, because no reason has been provided. Coming to the point that Article 15(1) is also being violated. Article 15(1) says state shall not discriminate anyone on the basis of their sex, which sex includes gender and sexual orientation, and thus basis on which they have discriminated in the society as to they cannot marry and have a bundle of rights as to adoption and surrogacy. To that extent, it is violative in nature of, it is violative and thus is unconstitutional, and should be interpreted in a manner that the doctrine of reading down should be applied and interpreted in a manner that they should include these people as well in the ambit of marriage and in section 5 and 4 of Hindu Marriage Act and Special Marriage Act respectively. Your Lordship, coming to the third contention, that is, it is violative of Article 21. Article 21 provides no person shall be deprived of his life or personal liberty except for the procedure established by the law. And Your Lordship, in the present case, their dignity is being challenged, because the ambit of Article 21 also states that right to life with dignity. And thus, in the Maneka Gandhi versus Union of India case, it was held that due process of law is to be incorporated and the law should be reasonable. But in the present case, the law is not at all reasonable, because it creates a differentiation, and also it is not based on equity, and also is not it is also violative of Article 14, that is equality, and thus is arbitrary and not fair and unreasonable. Thus, their dignity is being hampered, and that is why we want them to be recognized in the society as couples as well, like as heterosexual heterosexual couples, and thus we contend that they should also have the right to marry as all the peoples of heterosexual couples. And also coming to the point, right to Article 21 in its ambit covers right to marry of one's own choice, and which is also being violated in the present case, because these people are not given right to get married of their own choice, because societal pressure they have to marry a person of the other sex, and later on they go back to their sexual orientation and cheat on their partners, and which creates a disturbance in the society. And to solve that disturbance and to create a balance, we need to recognize them and also allow them to marry to each other, so that such social evils do not exist in the society anymore. And with your lordship, coming to the next contention, coming to the next issue, that is the issue number 2, I would further like to divide the issue number 2 in further 2 sub-contentions. First contention would be that the LGBTQIA community is prevalent in Indy, and the second contention would be fundamental rights are originated from human rights and should be considered as a fundamental right under Article 21 of the Constitution of India, and they should have the right to marry. Coming to the first contention, that the LGBTQIA community is prevalent in India, we have ample of cases in which we have seen that in the Khajuraho temples of Madhya Pradesh, there are depictions of lesbians, and also in our Kama Sutra, it is also they are termed as Swarinis, which is pretty evident that the customs have also recognized these existence of these communities and their relationship. Also, in the recent case of Navjit Singh Johar, which was in which the 377 section 377 was decriminalized, and also they were given recognition, but it did not provide a true remedy as to they can live in relationship but they cannot marry. How is it a true remedy, your lordship? Your lordship, to provide a true remedy, we need to give them the recognition that they deserve, that is they have all the bundle of rights as a heterosexual couple and all the people in general, and thus we say that it is violative of Article 1421. And coming to the next contention, that it is a universally recognized law, because in UDHR, in which the India is signatory to it, the Article 16 states every man and woman of full age without restriction of race, nationality or religion have the right to marry and found a family, which nowhere excludes the LGBTQIA community. And also India is signatory to ICESCR and ICCPR, which also states the same, that any man or woman of full age can marry anyone of their own choice and found a family, and they nowhere exclude LGBTQIA community, and thus we contend that they should be included in Article 21 as a fundamental rights, because it's a human right of a person to marry whoever they want to and in whatsoever manner they want to. But the impugned laws, that is Section 5 and Section 4 of Hindu Marriage Act and Special Marriage Act and other marriage laws, insofar as they exclude these LGBTQIA communities, are violative of human rights and the fundamental rights of such people, and thus we contend that they should be given this right and also the recognition in the society. I would further like to give the authority to the assertions made by this council. Your lordship, in the case of Arun Kumar versus the Inspector General in the Madras High Court, it was held that the expression bride occurring in Section 5 of Hindu Marriage Act will have to include within its meaning not only a woman but also a trans woman, also include an intersex person, transgender person who identifies herself as woman. The only consideration is how the person perceives herself. And also beyond the man-woman binary, there are as many 58 gender variations. Of course, we use the expression transgender as an umbrella term. So the law has already recognized them, but the true remedy is still not given. And coming to the next case, that is Navjit Singh Johar versus Union of India, in which the Supreme Court has held the Section 377 to be violative of the fundamental rights and was held unconstitutional. And thus they were recognized once again, and the society is also recognizing them. And to resolve the problem as to when, because homosexuality can be treated as a ground of divorce as cruelty, because we have seen ample of cases in which whereby heterosexual couples in which one of them is belonging to LGBTQ community by nature and has sexual orientation which is not heterosexual, would still be pressurized to marry a person of opposite sex just because of the societal pressure. And this is what we want to change. And also, your lordship, in the case of Also, Your Lordship, in the case of Unni Krishna, JP and others versus State of Andhra Pradesh, the Supreme Court held that Part 3 and Part 4 of the Constitution are supplementary to each other, and Article 21, the right to that the right, if violated, would be held unconstitutional. Coming to the next case law, which provides Shafin Janan versus Askokan KM, in which the court held that the right to marry of a person of one's choice is integral to Article 21 of the Constitution. The Constitution guarantees the right to life. The right cannot be taken away except through a law which is substantially and procedurally fair, just and reasonable. But in the present case, it is not at all just, fair or reasonable, because there is no rational nexus as to what the object is to be achieved, and there is no objective clarified in any of the manner. Also, Your Lordship, the legislature has not made any law in respect to their marriages, and Your Lordship, they are being denied of the fundamental rights, and this is why we have filed the PIL before this Honorable Court, so that their marriages can be recognized under these laws. Your Lordship, coming to the next case of Justice K.S. Puttaswamy versus Union of India, in which the right to privacy included had given a wider ambit, in which the right to privacy is an element of human dignity. The sanctity of privacy lies in its functional relationship with dignity. Privacy recognizes the autonomy of the individual and the right of every person to make essential choices which affect the course of life. And thus we held that their sexual orientation, the discrimination on which they are being done, is their violation of right to privacy and also right to life and right to marry, and thus is unconstitutional to the extent to which it denies them. And Your Lordship, coming to the next case, which is Badshah versus Sau Umra Badshah, Supreme Court held that the law regulates relationship between people, it prescribes patterns of behavior, it reflects the values of society. The role of the court is to understand the purpose of law in society and to help the law achieve its purpose. But the law of society is living but the law of society is a living organism. Sometimes change in law precedes social change and is even intended to simulate it. And thus we say that to change the social norms that a homosexual couple cannot marry each other is wrong, and to normalize this and to promote these couples, there needs to be a judgment in their favor, and that their marriages can be recognized and they can adopt and have bundle of rights that a heterosexual couples have. And thus we contend that these impugned laws are violative of Article 14, 15, 1 and Article 21, and thus are unconstitutional and should be read down in a manner that they include LGBTQIA community individuals to be get married. And also, Your Lordship, if Your Lordship have any questions with regards to the arguments put forth by the Council.
The statistics about the number of people involved?
The Council seeks ignorance, but there is a fair amount of people in the society who identify themselves within this community as LGBTQIA, but many of them do not identify them because of the societal pressure. And if we come up with a survey, the survey would not be reliable as to what is their sexual orientation, because of societal pressure. They do not reveal themselves. But if the judgment comes in their favor, then it would really help them to conduct a survey that is of the exact figure, Your Lordship.
One suggestion I want to give to you is, don't use abbreviations. Use in expanded form.
Indeed, Your Lordship, the Council seeks ignorance. If Your Lordships are satisfied with the issue number 1 and issue number 2, the Council seeks permission to call upon the co-counsel who would be dealing with the issue number 3 and issue number 4.
1 minute. The universal belief is marriage is for procreation of children. Understand this question. Okay? So the laws are founded on our historical, ethical and moral values and beliefs. So our laws recognize the relationship between man and woman. So Hindu Marriage Act or Special Marriage Act, which recognize marriage between a man and woman, represent the will and aspirations of citizens of this country.
Indeed, Your Lordship.
So how do you think you are equally placed on par with couple having man-woman relationship. That is first question. If you want to note down, you note down. Second question you want me to ask? Answer first question.
Your Lordship, it is true that one of the aspects of marriage is procreation. But looking at the figures of the children who are in the orphanages, who needs to be adopted, that is also a significant figure. And also heterosexual couples who are infertile, what about them? Also they cannot procreate.
No,
But
adoption will come later. First you answer this point.
indeed, Your Lordship. Your Lordship, procreation is one of the
It is a
aspects.
universal belief that it is meant for procreation of children. The relationship should be between man and woman.
Indeed, Your Lordship.
Man and man relationship and woman relationship. It is not meant for procreation of children. So it is deemed or it is understood. It is unnatural. The relationship between man and man, woman and woman is unnatural. Relationship between man and woman is natural. That is what our Indian system, Indian laws recognize. And that recognition is found in Hindu Marriage Act and other marriage acts, special marriage acts. So how do you think you are equal on par with couple having man and woman relationship? How
Lord-
can you claim equal status?
Your Lordship, to the point to which the procreation is being challenged, procreation is one of the aspects of marriage, and marriage solely does not solemnize just because to procreate. There are many aspects of marriage, because in Hindu marriage, if we see ceremonies, it is not just related to procreation,
What are the other
but the
aspects of
individuals.
marriage other than procreation?
Your Lordship, love, affection, care, the vachans in the vachans which the couples take does not include just merely procreation of children, but to protect each other, but to stand by each other's side and to have each other's back is something that should be considered in par with procreation. And procreation is not the main function of marriage. Marriage is between two couples, is based on the understanding and the love between them.
So, yes, let us pause here. If procreation is not the main purpose of marriage, and if the couple are only interested in love and not children, so we only have love, there will not be any children for our future generations. And how do you address that issue?
Your Lordship, it's the couple's choice. In the society, we have seen couples who do not want to procreate, even though they are capable of. And this is the society we live in, where people have choice, and that is the fundamental rights being guaranteed to them, because they can make their own choice. And thus, it is their choice how to have children, not to have children, or whether to have children. And thus, we say that this right should be recognized of these homosexual couples as well.
Then what is the... Don't you think there is an intelligible differential?
Indeed, Your Lordship, there is an intelligible differentia,
Couple
but
having man and woman relationship and between lesbians having relationship.
Your Lordship,
There
there.
is a difference. You can place them in two different classes.
Indeed, Your Lordship, but dividing them without any reasonable nexus to the objective sought, and as to what object is being sought, is not a ground which can be taken. If there is an objective to which there is a rational nexus, then we can consider it. But you are dividing a class amongst a class which is not at all allowed. And we have seen the test of reasonable classification in the case of Anwar Ali Sarkar versus State of West Bengal, in which the test of arbitrariness was given, whereby the reasonable classification was discussed as to there should be an intelligible differentia with rational nexus as to objective sought. But in the present case, there is just intelligible differentia and there is no objective sought as to whatsoever. Why are they dividing the class and why are they discriminating against them?
You can claim equal status when everything is equal. Man and woman relationship, keep it on one side, woman and woman, man and man relationship another side. There is a difference, that is our opinion. How do you say you are not different?
Your Lordship, they all are human in nature and they all have human feelings. We are differentiating them based on nothing. There is no intelligible differential as to ever, because there is no rational nexus. There is no way you can divide humans amongst humans. As to their feelings are same, they all are humans and also they want the same rights as to what they want to do in their life. And thus we say that it is based on just intelligible differentia that they have divided a class, but no objective has been given as to whatsoever why are they dividing the class, because a lesbian couple have the same feelings for each other that a heterosexual couple might have, and this is the case which we are dealing with, and thus we.
Objective, that is what we said. Man and woman can procreate children. Man and man, woman and woman cannot procreate children. So there is a difference.
Your Lordship, to the question of procreation, these couples should be allowed to have right to adopt and have surrogacy, and thus they can raise a child. Procreation, the main essential of procreation is to have to continue the family, and for the continuance of the family, these couple can be granted rights such as surrogacy method and adoption so that they can continue their family as well. So there is no intelligible differential in the present case.
Okay.
Much obliged, Your Lordship. The Counsels,
One more question.
indeed, Your Ladyship.
Our marriages, adoption, everything are under personal laws.
Indeed, Your Ladyship.
Personal laws. You want them to be recognized under the personal laws.
Your Ladyship.
They may be of each personal law, whether the Muslim personal law and the other personal laws are
Indeed, Your
also
Ladyship.
different.
Indeed. Your Ladyship, personal laws, marriage is a social institution which impacts the society at large, and also in the present case the petitioners are Hindu women, and they want their marriage to be recognized under Hindu law, and the Hindu law does not recognize it, but it is unconstitutional in nature, and I have proved that way, because to commit ceremonies, because for Hindus a marriage is a ceremony, and to commit and to solemnize their marriage under Hindu Marriage Act, there needs to be ceremonies performed. But if we deny them, then those ceremonies would not be able to be performed by them, and thus we say that there should be a change in the personal laws as well, and in Special Marriage Act and other laws to the extent which they deny these couples to be married. Much obliged, Your Lordship. The Council seeks permission to call the co-counsel for the issue number 3 and issue number 4. Much obliged.
The Council seeks permission to continue with the third and the fourth issue. Much obliged, Your Lordship. Issue 3 states whether the denial of right to adoption and right to get child through surrogacy to an LGBTQA couple is violative of gender justice and gender equality. Your Lordship, Section 2(1)H of Surrogacy Act defines the definition of couple, which only includes a married man and a woman in a definition, and also the age criteria is given, and it allows only an Indian man legally married to a woman who can initiate the process of surrogacy. And if we talk about the Adoption Regulation Act, it gives certain criteria for the adoptive parents, and the petitioner has fulfilled all the criteria. They have denied the right to adoption just for the sake of non-production of marital certificate to them, to the authority. So these two laws are very much in violation of gender equality and gender justice. Thus, these laws should be rejected or struck down to the extent they include the LGBTQ community in their definitions. For these, the Council have divided the contention in 3 parts, that these provisions are arbitrary in nature, unreasonable, and it hampers the right to dignity. If we talk about that, what the arbitrary is, arbitrary means, according to the Black Law Dictionary, arbitrary means it is unreasonable manner as fixed or done without adequate determining principle, not founded in the nature of things, non-rational, not done or according to the reason or judgment depending on the will of alone. In short, if we define arbitrary, means that it is uninformed by a particular reason and acted in its own will and without determining the principle. My counsel has already dealt with Article 14, which provides right to equality and right to equal protection of law in the society. If we talk about Surrogacy Act, why it is arbitrary in nature? arbitrary means they intentionally not included such couples in the definition such community in the definition of couple. They explicitly not included such, and they because of which they are not getting a bundle of rights through this. And if we talk about the Adoption Act, the regulation has provided the main three classes, that the marital couple can adopt it, the single female can adopt it, single male can adopt it, but not these a couple of these community. The question from the council is that if a single person is capable of bringing up a child in the society, why not two couples? It is a very much in benefit of a child and the best interest of a child if two persons getting them and bringing up in their house. If we talk about arbitration, there is one test of
What provision in the Adoption Regulation Act you are challenging?
Regulation 5. If there is a test of manifest arbitration where it is if the provision is very much arbitrary in nature, to prove it there is two contentions, that it is excessive and disproportionate. So if we talk about Surrogacy Act, it is very much disproportionate and excessive because they have not included the couple. They just bifurcating two things, that heterosexual couples and homosexual couples, and not even homosexual couples. All the community of LGBTQ here, whether the combinations of all the LGBTQ, they have not included in the definition of couple. If we talk about the Regulation Act, the manifest arbitration disproportionate on the basis of classes. That I already stated that there are three classes they have classified, and on the basis of that they have given adoption rights to single persons as well, but not to the couple. If we talk about the reasonable classification, as already stated by my co-counsel, that what the reasonable classification is, and there are two tests to fulfill whether this there is unreasonableness or not. So these two provisions do not fulfill the criteria or the test which is given under so many judgments, like State of West Bengal versus Anwar Ali Sarkar. They have provided guidelines and the tests. The test said that the classification must be found on intelligible differentia which distinguish person or thing grouped together from the person left out from the group. Yes, we do agree that there is precedent that equal should be treated equally and unequal should be treated unequally. But sir, if we talk about the classification, there should the Article 14 permits reasonable classification and not the class legislation class. The class legislation means making an improper discrimination. And if we talk about the very purpose of these two acts, it's to provide children to the one who are not having it. And also for other purposes as well, to protect the interest of child. I agree. And also if we talk about surrogacy, the one who cannot procreate, this is the main thing in the act, that the one who cannot procreate can get child through surrogacy and adoption. So these laws from council side is very much in the need for the community of LGBTQ, because they are the one who cannot procreate but still want to have family according to their desire and sexual orientation and their preferences. If they want to start a family, and even if we talk about the personal development, even if we talk about our culture that the family considered, traditional family can consider as a family of two and having children, and they are upbringing them in a family. So these things are very much desired by the community of LGBTQ as well, and thus these laws are very much in violation of Article 14 basically. And the contention also, Your Lordship, in the landmark case, the Baby Manji versus Union of India, the Honorable Court has, for the first time, they had dealt with the question that directly linked to the surrogacy. It was in 2008. the court therein recognizes surrogacy as a medium of embarrassing parenthood and accepted that the parent may be a single or homosexual couple. The latter is neglected by the legislation and they have not included it. The question is here that when you can give the liberty to the person and can recognize through the judgment under judgment of Navjit Singh Johar, and you are giving that much liberty and you are recognizing such community in our society, then why we are lacking the bundle of rights in the society? Why we are not getting equal treatment in the society? If we talk about the dignity is hampered as you have given the right to us and you put the restriction over it that you are not included in this and you are not included in this. This is very much hampering their dignity. They are recognized in the society through judgments, but they are restricted by certain laws and they are not treated equally in the society. So giving respect to someone, that means giving full respect to someone. It doesn't that you shouldn't be restricting certain areas or creating class legislation in our society. Any question regarding to the third issue?
You want to argue fourth issue or
Yes.
you want me to ask
Third issue.
third issue? See, surrogacy is in one way a medical intervention. What is not possible through natural process was made possible through medical intervention. So a couple cannot have children. They are given a choice. The medical process, you can have children. How can you say that you have same problem or same status as compared to man and woman?
Your Lordship, the thing is,
You please understand the question.
much of
Surrogacy is an alternative mechanism. It's the medical. What cannot be achieved through natural process, you are making it possible through medical process. You cannot achieve through natural process. So why do you want the same treatment to be given? And how can you say that you have to be given parity with man-woman relationship?
Your Lordship, the answer is here in the question only that the act, the main purpose of the act is to provide children to the one who cannot procreate. Even if it is scientific, they are also cannot procreate. Thus, they should have given this right of to get child through surrogacy, Your Lordship. So, how they are different? Even the heterosexual couple cannot procreate, and the homosexual couple cannot procreate. The objective of the act is same: to provide child to the one who cannot procreate. So, on the basis of these community, we cannot differentiate. It is a process that yes, on these grounds, on these objectives, we are here, and the legislation wants to fulfill the idea or intention of of this act is to provide children. It is to provide children to one who cannot procreate. So the definition of couple is very limited. It should be gender neutral, Your Lordship.
The surrogacy child is born through reproductive process of man and woman, not through natural means, through medical process. So, is the same reproductive process present in man and woman relationship?
Your Lordship, if we talk about the process of surrogacy, the another woman, the surrogate mother, provide her egg to the couple who are infertile. In this also,
Where are you getting man and woman reproductive process? I am telling you.
they are stored in the clinic.
Woman and woman and man and man. You are borrowing it from other person.
Yes.
You cannot compare now because there are two separate genders and women may borrow it from men, but women cannot borrow same.
Your Lordship, in heterosexual couple as well, they borrow act from another woman. Yes. So even this homosexual couple can borrow acts from another woman.
You can borrow. But at the same, we are not saying you cannot borrow. We are saying you cannot be treated on par with them because there is an intelligent differentiation.
Your Lordship, the thing is, if we talk about only a surrogacy process, so surrogacy process is totally same for homosexual as well as for heterosexual. Heterosexual cannot procreate themselves, that's why they are borrowing the eggs from the mother, right? And if we talk about homosexual couple, they cannot procreate, that's why they are borrowing. So the intention of both the couples are same. We cannot, differentiate on basis of this, Your Lordship.
What about the child? The child should have support of mother and father.
Yes.
Joint affection of mother and father.
No.
If the same sex
No, Lordship.
have a child, then they will have only mothers or fathers. They won't have father and mother.
Your Lordship.
How are you going to reconcile them?
Yes, sir. Your Lordship, indeed, the thing is, in our society, we also have the concept of single parents. And how they are growing up their
Single
children.
parent is different. One partner can die. Living relationship is recognized. That is different. But now we are concerned with two parents of same sex. Please answer.
Your Lordship, I'm a little bit confused by your question that what are you seeking from us?
Our question is, when a child is born, child should have love and affection of mother and father. Here, child is deprived of one parent.
Your Lordship,
So there is a difference.
Your Lordship, if a woman is carrying a child and father dies before the birth of the child,
That's why we said we are concerned not with one parent, we are concerned with two parents of same sex.
and also we have this concept of equality where the woman and
You are
a
thinking about the rights of couple. You should also think about the next generation. What about rights of children? Is there no deprivation of rights of children? You are concerned about your rights. What about children's rights? The lawmakers will have to think about children. The child is deprived of one parent's love and affection. How are you going to reconcile that situation?
Your Lordship, if we talk about equality in this society where the woman and the man are equal on pedestal.
Let us assume you are equal. I am talking about your child.
Yes, so he will get all the benefits from two single
From where will
male
he get? Suppose you are two women. From where will he get father's love?
because there is equality. What all work father can do, the mother can also do. The mother can also work. If
Homosexual couple also play the role of father.
father and the mother,
Yes, correct.
yes.
Go to the next issue.
Much obliged, Your Lordship. Oh. The recognition, the council seeks permission to continue with the fourth issue. Much obliged, Your Lordship. If we talk about that the society has given right and through the judgment Navjit Singh Johar, they had decriminalized section 377 of IPC where they have recognized the community LGBTQ. Oh, so when they have given liberty to them to live together, this particular judgment is only having a damaging effect on our society unless such union is recognized. If you can live together, if we take the simple example of our society, even if a boy and a girl is living, the society will see them in such a manner that they are doing something illegal. So when you are giving right to someone to live together, then why not a status in the society? If we talk that, if we perceive this thing that they get bullied in the society, yes, of course, they get bullied. That's why we are asking for the status, that they should get the status not to get bullied by the society and have certain status in the society. And also in Shakti Vahini versus Union of India, it is very much clear. The judgment has given right under Article 21 to choose partners. This is irony, Your Lordship. You are giving on one pedestal, you are giving someone, the community of LGBTQ, to live together, and in one case you have given right to choose partners. Then also the union of if the LGBTQ couple is wanting someone or want to desire to live with someone, so why they do not have choose to right to choose their life partner? So these two, if we conclude, if we join these two judgments, this is irony on the part of legislation. Also, if we talk about if we talk about the bundle of rights that heterosexual couple get, you have given the status of status to the LGBTQ community to live together, but they are not getting a bundle of rights like succession, inheritance, divorce, maintenance, and all of these things. So they are deprived of such rights. And to make this relationship stable, and for the, if we talk about, again we talk about the best interest of a child, the status is very mandatory. If they are not recognized by the society, if they are not having any status in the society, the child under that is not getting any best interest. For that, we need to recognize their union so that they get a status and thus get bundle of rights and thus be treated equally to the heterosexual couple. And also, if we are not providing bundle of rights to them in the society and not the status in the society, mere giving liberty to live together is hampering their dignity, and they do not have a particular position in the society. Any question, Your Lordship?
Section 377 IPC is struck down by the Supreme Court. Now, while striking down that provision, Supreme Court has not created any rights. It has only decriminalized. Over a period of time, court found that there is sexual orientation. People have different choices. So, since it affects their dignity, ultimately this independence law was declared unconstitutional. And by doing that, the court has not created any new rights as such in favor of these class of people, so as to make them entitled for recognizing their group as a union. So what is your fundamental right to claim that your union has to be recognized?
Your Lordship, in Navjit Singh Johar case, the court decriminalized this particular section. That means they have give liberty to the couples that they can live together. So, if we talk about this, that you, through this judgment, has recognized this particular community in our society, that they exist. If something is exist, we need to give, because our country is democratic, everything which is existing, we, the legislation have this duty to protect their right as well.
Every couple, man or woman, see, they have different sexual orientation. They don't have anything in common as such. only people who have got common object. They can come together, form an association or union and seek recognition. You don't have any common object as such. But you have individual rights. You don't have common rights. Rights which can be recognized as union rights.
Your Lordship, it is a community of bigger, wider ambit. LGBTQIA plus. That means it is considered of so many different combinations. Even the permutation combination cannot, calculate. So it is not a very small percentage. It is at a wider ambit.
It is not the percentage or population. We are saying when you take instance of a group of people, they have got common object. Here every person has got individual preferences, choices. There is no common object. That is our
The common object, Your Lordship, is to choose the partner of their choice. This is a common object. So we want that in the definition of couple and all, there should be a gender neutral law that treat each and everyone equal. So the object, the common object the council take is to get a partner of his or her choice. So satisfied with the fourth issue, the council seeks permission to continue with the prayer. And stated above, it is most respectfully prayed that the Honorable Court may be pleased to issue a writ of mandamus or any other appropriate writ, declaring that Hindu Marriage Act 1955, Special Marriage Act 1954 and other marriage laws ought to apply a marriage between any two persons regardless of their gender identity and sexual orientation or in alternative. Declaring that the Hindu Marriage Act 1955 and Special Marriage Act 1954 and other marriage laws are unconstitutional and violative of Article 14, 15 and 21 of the Constitution of India, insofar as it does not provide the solemnization of marriage between a same-sex couple. The right to marry is a universal recognized right, thus can be claimed as a fundamental right under Article 21 of the Constitution of India. The denial of right to adoption, surrogacy to LGBTQI is violative of principle of gender justice and gender equality incorporated under Constitution of India. The LGBTQIA+ have the right to get their union recognized through the way of grant of certificate and thus can enjoy all those rights as that of opposite sex couple. The Honorable Bench may also be pleased to pass any other order in the light of justice, equity and good conscience. The council seeks permission to go back.
yes.
Thank you.
Left side all things are completed.
Your Lordship. Much obliged, Your Lordship. Today, Your Lordship, I am the counsel for the respondent in the instant case. Your Lordship, if the Lordships are well versed with the facts of the case, the counsel seeks permission to proceed with the arguments.
Just wanted to know the basic question, who is the respondent in this case?
Your Lordship, it's a union of
Is it a state?
Union of India, the
Is it a
states.
state?
You are
or,
representing state or individual organization, suppose in the writ petition.
Petitioners are, you know that some private parties are there. Who is the respondent in this case?
State, sir.
State. Please go ahead.
Much obliged, Your Lordship. If Your Lordships are well versed with the facts of the case, the council seeks permission to proceed with the contentions. Your Lordship, I will be dealing with the first two contentions, and the next two contentions will be dealt by my co-counsel.
Much obliged, Your Lordship. Your Lordship, the first contention is that Section 5 of Hindu Marriage Act and Section 4 of Special Marriage Act that restricts the marriage of same-sex couples are not violative of Article 14 and 21 of the Constitution. Your Lordship, I would like to point at the definition of the Hindu Marriage Act. That is, Section 5 of the Hindu Marriage Act 1955 clearly mentions that marriage can be solemnized between two Hindus. But if we look at Section 5, Clause 3, it has clearly mentioned that the marriage can be solemnized between couples who are that is bridegroom and bride above the age of 21 and 18 respectively, which clearly explicitly mentions that the marriage can be solemnized between heterosexual couples. Similarly, if we look at the Special Marriage Act, that is according to Section 4 of the Special Marriage Act 1954, we can see that marriage can be solemnized between any two people. Here, if we look at Section 4, Clause C of the Special Marriage Act, it clearly mentions that marriage can be solemnized between any two people who, that is, a male and a female above the age. Section 4, Clause C clearly mentions that marriage can be solemnized between a man and a male and a female who are above the age of 21 and 18 respectively. So here this law is created with the objective of solemnizing the marriage between a man and a woman who are of interfaith religion. So it clearly explicitly mentions that the marriage can be solemnized between a man and a woman. Coming on to Article 14 of the Constitution, we can see that these provisions are not been violating the Article 14 of the Constitution. If we see that the Registrar of Marriage, who has denied the registration of marriage of Nivira and Diya, have performed his act in accordance with the law, and he has, as the law does not expressly mention anywhere that the same-sex marriage can be allowed. As we can see, there is a legal vacuum regarding same-sex marriage. There is the same has not been recognized anywhere. So we can see that there is no violation of fundamental right. So if we refer to the case of Navtej Singh Johar case of 2018, herein the Supreme Court has held that same-sex the sex between same genders is allowed, but it has nowhere mentioned about the recognition of same-sex marriage, and it is far away from the societal norms and the constitutional morality. If we look at the concept of constitutional presumption, we can clearly see that any legislation.
What is the constitutional morality? What do you mean by it?
Your Ladyship, here we are the laws which we are. Morality is seen as per the constitutional morality and not as per the morality understood by the society.
That's why I'm asking, what is the constitutional morality which is violated? You are not concerned with the morality of the society or majority of the society. You are now challenging the constitutional morality.
Our nation has not consented or not restricted the consensual sex between two people of same gender, but we have not recognized the marriage between same-sex marriage, Your Lordship. If we look at the case of
So as per you, we go with the majority of the population. constitutional morality also goes with the majority opinion.
Your Lordship, if we look at Article 21 of the Constitution, it clearly mentioned that all the rights which are mentioned are subject to the procedure established by law. By this principle, we can tell we can tell that certain legislation certain legislation can be curtailed by the procedure established by law, and it is for the good of the public at large. Your Lordship, in the case of Nalsa versus Union of India, the Supreme Court has recognized third gender as a category, and by which we are in tandem with the present legislation. Your Lordship, in the present law of Indy does not differentiate. The present law of Indy does not differentiate on the basis of sexual orientation, and the marriage can be solemnized by anyone according to the Indian legislations. If we come to Article 21 of the Constitution, it has that is right to life and liberty. It has not been violated, Your Lordship. Keeping in mind the case of Puttaswamy case, which has rightly held that the sexual orientation and such other things are the personal choice of the individual, and the provision of law in question herein is merely the recognition of the social recognition, merely the social institution that deprive of marriage. That is merely herein the question is about the mere social institution of marriage, and in no sense deprive the right to dignity and life, as they are allowed to live their life together and choose their partner of their own choice. Herein we have merely restricted the social institution and nothing else, Your Lordship.
How does the individual choice affect the public good?
Your Lordship, if we look into the Indian perspective and the Indian culture, the concept of same-sex marriage is not recognized here. The fundamental objective, the main objective of marriage is procreation. But if we see in the case of same-sex marriage, this is against the nature, and it does not. That is why the question does not arise.
One of the arguments is that Article Section 5 of Human Marriage Act and Section 4 of Special Marriage Act has to be read down. So that is one of the things of their argument. They say provision has to be read down to include same-sex marriage couple. What is your argument on that?
Your Lordship, as there is no no violation of Article 14 of the Constitution, we cannot. There is no violation here.
So do you say that it cannot be, even if there is no law today, why can't we read it down so as to include them in Section 5 of Human Marriage Act and Section 4 of Special Marriage Act?
Your Lordship, the choice of personal and there is we respect the choice of that is personal, and we agree. Therefore, in why is the question of unconstitutionality is asked is to be rendered.
B77 was struck down. Don't you think same-sex marriage is recognized in a way by constitutional court?
Your
They are entitled for equal rights.
Your Lordship, if we look at Section 377 of IPC, it has partially repealed some of the provisions with respect to consensual sex between between couples of same gender. But if you see, other things are as it is. Here, if you see our current society and the Indian legislation is not in the position to accept the recognition of same-sex marriage and is far away from it. Your Lordship, the Council seeks permission to proceed with the second issue. Your Lordship, according to Article 21 of the Constitution, that is Article 21 of the Constitution that includes right to marry and have a family, but it is subject to the procedure established by law. That is by way of the codified laws and the customary practices. The rights granted under Article 21 can be curtailed. For this, I will be taking the help of few of the cases which has stated about this. If we come to the case of A.K. Gopalan versus State of Madras, here the Supreme Court has clearly stated that Article 21 of the Constitution can be curtailed if it is by the procedure established by law. Similarly, in the case of R.C. Cooper versus Union of India, the Supreme Court has clearly said that fundamental rights are not comprehensive code, and it can be amended and evolved over the period of time. Further, in the case of Maneka Gandhi versus Union of India, the Supreme Court has expanded the scope of the procedure established by law by including the concept of natural justice, which is not, as we have already established, it is not violating Article 14 of the Constitution. Hence, this right, this restriction can be sustained. Therefore, if we look at the following things are the procedure established by law, which restricts the rights given under Article 21. It's not it's correct. Therefore, Article 21 of the Constitution is not violated in the instant case.
All the citations cited by you are fundamental rights can be expanded. But now you are saying that they can be restricted. They are not restricted. They need not be restricted, or now they are restricting their rights. So why can't they be expanded to include their rights? To include them also as a part of the society.
Your Lordship, if we look at the next issue, which talks about the union,
We are going to the next issue.
the
Our
sub-issue.
is in the next issue.
Yes, Your Lordship. Your Lordship, if we look at the union of marriage of LGBTQ couples, and they getting married and having a family, it has a structural lacuna in itself. If we look if we keep at the child perspective in point, the child will have a negative impact on his mental health, and he will be bullied by the society, being as the parents of as being the child of the same-sex couple, and will be having problem identifying his individual sexuality. In the
Are you supported by any study or survey?
Your Lordship, if we look in the instant case, there is no research regarding.
How can you say that there will
Your Lordship, this will be dealt by, we will be submitting the, it will be dealt by my co-counsellor in the further arguments.
Don't you think these human rights and universally recognized rights are facets of fundamental rights? So what is universally recognized and what is ignorant? In this case, same-sex marriage is recognized, universally accepted.
Your Lordship,
Why can't it be part of fundamental right when there is an acceptance everywhere, universal?
Your Lordship, the foreign laws and the international laws are not binding on us.
Even our Supreme Court and several other high courts have recognized same-sex marriage.
Your
Why
Lord,
can't they be treated?
India is part of the United Nations Conventions and everything.
yes, Your
Why they are not
Ladyship.
binding on us? Our laws should be in accordance with the universal declarations and everything.
Your Lordship, even if we have ratified, it depends on the nation that whether as per the societal values it should be applied or not. So we should think about the society at large, keeping the public at large in mind while deciding such sensitive matters.
When same-sex marriage is not illegal today, why can't they be treated equally? Same-sex couple and opposite sex couple, why can't they be treated equally when the relationship between same-sex couple is not illegal?
Your Lordship, we are not discriminating between any of the genders. Only our provisions under Indian legislation that is in the instant case, that is Section 5 of Hindu Marriage Act and Section 4 of Special Marriage Act, it clearly mentions that marriage can be solemnized between a man and a woman irrespective of their sexual orientation.
You are not allowing them to adopt. You are not allowing them to be recognized as a couple. You are not giving them any certificate. How can you say that they are not discriminated?
Your Lordship, the law does not recognize the concept of same-sex marriage in India. If we look at the pros and cons of the instant case, there are more cons compared to the pros in the instant situation.
What are the cons? That's what we want to know.
Like when it comes.
How would it affect the body?
Your Lordship, this will be dealt by my co-counsel. Your Lordship, in the case of Rajeshwari Chandrasekhar Ganesh versus State of Tamil Nadu, the Supreme Court has clearly said that while deciding about the custody of the child between two spouses, there was an issue regarding whether the child should be given to which of the parents. So here the Supreme Court upheld and that the priority and the child should be kept in priority while deciding to whom the custody should be given and under whom he or she will be benefited more. And the same we can see under Article 3 of Universal Declaration of Human Rights, wherein we can see that the same thing was said, where the child was kept in priority. If we look at the case of Oklahoma Supreme Court, which is the welfare.
Interest of child is kept in priority. There is a difference between those two also.
The interest of child is kept in priority.
Have to be specific.
Further, in the case of Oklahoma Supreme Court judgment, the lesbian mother had to prove that she was fit to be the mother, as her status was a lesbian. and she, as there was an issue in whether the lesbian couples are able to take care of the child or not. If we look at all the things, we can see that if the child is brought up in such an environment, he or she will have a very negative impact, because in Indian perspective, it is not been accepted, the concept of homosexuality, and it will cause negative impact on the child. If your lordship have no further question, my co-counsel will be dealing with next two contentions.
You are done.
In violation or not of the equality principles and the gender justice norms that are in the Constitution of Indy. Now first let me preface this by saying, when we talk about gender justice and gender equality principles, we inherently look at Articles 14 and 21, and that is on the basis on which I will continue my contentions. When we start with Article 14, I'd like to quote a case here, which is that of Ashutosh Gupta versus State of Rajasthan, when it was clearly stated that equal treatment can be given only in equal circumstances. Now, how do I bring this in tandem with surrogacy? And let me preface also by saying that I'll first be dealing with surrogacy, and later on how adoption will cause a problem. To deal with surrogacy. Now, the Surrogacy Act of 2021 clearly states that adoption can be done by a married couple and only in situations where they are unable to have a child. Now, how do I say that these circumstances are not equal? Now, the circumstances are not equal because the fraction of heterosexual couples unable to procreate and procure an offspring is very limited compared to the number of persons in homosexuals who will be able to procure an offspring. Because in the case of homosexuals, the act of procreation, yes, can take place, but will that result in anything? No, it is merely for the pleasure. Now, when we bring this in mind, how can we say that the circumstances are equal? Because unless a disease is to possess the entirety of human race, whereby heterosexuals are unable to procure a child by procreation, the faction limiting homosexuals and heterosexuals, there is a stark difference in the quantity. And now how does this cause a problem? The faction of heterosexuals who are not able to procure a child will be very limited. However, if the mandate is applicable to homosexuals as well, surrogacy as a concept will apply to those couples as a whole. When this applies to them, any and every couple would like to have an offspring or procure an offspring which they're genetically related to. When this happens, majority of the homosexual couples will proceed to the concept of surrogacy. And when they do this, surrogacy will inherently be reduced to a commercial nature. And when this happens, the woman inherently will be reduced to a commodity, and the interest of the child or the interest of the health of the mother and the child will not be taken into consideration. When this becomes commercialized, we will be violating the right to health of millions of persons for the right of recognition of a small fraction of persons. And this, in light of public good, is very, very, very detrimental to the society at large. Coming to my next contention, where I'll be dealing with Article 21. Now, this is also in relation to Article 14. While we have now established that there's a difference because there is an inequality of circumstances with respect to the number, Article 21 deals with a plethora of rights that are granted. And yes, is recognition of rights for different factions important under this article? Yes, but at what cost? The question before this honorable bench is right to health versus the right of recognition. Now, for the recognition of a few, are we going to compromise the greater good of different persons? Yes or no? Before this honorable bench, can we, the question that is posed is, can we compromise the health of millions? Can we compromise the life of millions of women when we are putting at stake the rights of few persons? Now, the current societal stigma, first of all, does not even support these couples, does not even recognize it at large. Yes, the landmark Navteej Singh judgment, which has been quoted umpteen number of times, has been stated that yes, there is a decriminalization done. But how are we equating a decriminalization of an act to to the acceptance of the society at large. There is absolutely no rationale to it. When you are saying no, and let me quote, this is section 377 of IPC, which talks about a punitive act. So we have merely by virtue of the Navtej Singh judgment stated that there is a decriminalization that has happened of the act. This in no way states that the society or the constitution at large supports the act of supports same-sex couples. This is inherently a very vague assumption and a positive utopia that is created by the Council for the Petitioners, wherein they hope and pray that this judgment means the recognition of the LGBTQIA couples. Otherwise, it really does not, and it is mere decriminalization that has happened. And further, when we homosexual couples as well. Now, they are going to be moved from an institution where by and large how and what their treatment was done is not disclosed to anybody. We are hoping for the best, but what is in fact happening is in question. However, we are transferring them to a couple whose recognition A is limited, and B, for against whom the society is very much against, possesses a stigma, and is very much biased. So we are subjecting these children from an institution to come to a society where their family is not accepted, where they will not be accepted, and where they will be ostracized, or they may be ostracized. Now, yes, is there the same problem can occur in case of heterosexual couple adoption? Yes, problems may happen. But the difference over here is, in case of heterosexual couples, there is a slight ounce of ambiguity wherein something may or may not happen. Over here, there is an established societal norm, established custom, established practice, and established morality that has already been existing, and we, against all such norms, are going to allow them to be adopted and be faced with such stigma, knowing that this will definitely take place. How is that in right with the best interest of the child? And that is by far the actual application of Article 3 of UDHR, which says the best interest of the child needs to be taken care of. When we know the interest of the child can be affected by this, granting this right of adoption to homosexual couples is starkly opposite to any and every declaration that is made. Do your lordships have any questions with respect to issue 3 at this point?
Article 15 clause 1 is state shall not discriminate any citizen or so on so forth, including sex.
Indeed, your lordship.
So don't you think there is a discrimination on the ground?
Indeed not, your lordship, because the right to marriage, like the registration of marriage or the so-called concept of marriage under section 4 of Hindu Marriage Act and Section 5 of Hindu Marriage Act and Section 4 of Special Marriage Act is actually a norm that is applicable on everyone, and there has been absolutely no differentiation done. This is applicable to this set of people or it is applicable to that set of people. It is a blanket application on everyone. It is the classification made by the other person with respect to this is not applicable to me. When the law was enforced, when it was imbibed, and when it was accepted and upheld in umpteen number of judgments, there was no bar done on the concept of sex or so-called sexual orientation, because it is an application on everybody. Whoever chooses to marry, the law says for the social institution of marriage, you have to marry in this particular norm, and that bars sexual orientation because that is not even bringing up the concept of sex. It is just saying the concept of marriage includes a man and a woman, and that is based on umpteen number of customary practices, umpteen number of codified laws, all of which have been upheld before this honorable bench.
Today it is recognized in India that same-sex marriage is not illegal. So why can't they be permitted to have a surrogate child?
Your lordships, firstly, I am not aware that it has been that same-sex marriages have been recognized, and second of all, as
It is not illegal.
Oh.
Not illegal.
I apologize.
It is not illegal. Do you admit that? Same-sex marriage is not illegal.
Your lordships, the ceremony within itself, wherein it includes or encompasses.
Legalized or not, it's a different question. Today it is recognized in a way.
Your lordships, the relationship is recognized,
Yes.
but yes, the relationship is
Why can't they
recognized.
have when living couple having a living relationship can have a child? Why can't a couple of same gender marriage?
Your Lordships, because when we talk about homosexuals admitting to the concept of surrogacy or being included within the concept of surrogacy, as I said, if it's a right given to one, it's a right given to all. That means we are providing a number of couples this concept, this attempt or opportunity of surrogacy, which means surrogacy will inherently become a commercialized task more than a medical help that is given to a small faction, and that will inherently affect the rights of women. And as you quoted, Your Lordship, Article 15 Clause 1 bars discrimination based on sex, but the same article in its Clause 3 states that special rights should be given to women and to children. So why are we putting the rights of millions of women at stake to provide this right of surrogacy to a small faction of persons?
Commercialization is connected to heterosexuality or homosexuality.
No, to homosexuality, Your Lordship.
How this commercialization of surrogacy, which you are attending, is connected to either homosexuality or heterosexuality?
It is relating to homosexuality, and Your Lordship, the contention that is based over here is because for heterosexual couples it is a medical help that they need in very certain or specific circumstances, and that is basically a small faction of people. Whereas when we talk about the LGBTQIA plus couples, they will accept this as a mandate because they definitely cannot have a child of their own. So when they do this, that will essentially become, it might not start off as that, it might start off as a medical intervention, as Your Lordship said, as a medical help, but it will ultimately lead to commercialization. And this is an end which we can foresee, because in case of homosexual couples, the concept of procuring a child the natural way is scientifically impossible.
When a single parent and
Yes.
adopt a child,
Yes, Your Lordship.
why can't two parents of same gender?
Your Lordship, precisely. When we talk about single parenthood, there exists a plethora of difficulties that even single parents face, and these are the kind of difficulties which some are foreseeable, some are not foreseeable. However, when we talk about homosexuals, the difficulties are foreseeable because societal norms, societal stigma, morality, all those things come into play, and all those things are already existing. We see it. Why would we subject a child to a trauma which we already know will be there? And there have been studies that have been shown in the, at least in because since there are no studies in India because the circumstances have not happened. In the case of America there and Canada, there have been studies that have been quoted by way of their economics journal and by way of their development psychology journals, wherein they have said that these children have faced physiological, psychological differences, they've had gender identity issues. Then in case of lesbians adopting children, there have been girl children who have been more prone to teen pregnancies, etc., because the absence of a male model and all those things. So these studies scientifically show, and these are nationally recognized journals within America, which have shown these kind of problems to subsist when this kind of right is given. So subjecting children from an adoptive institution to a place where they will be subjected to more trauma or more problems is absolutely uncalled for and very unfair to the child for no fault of their own. Yes, Your Lordship. Much obliged, Your Lordship. I'll be dealing with the final issue of the case, wherein we talk about recognition of the same-sex marriages and giving them a certificate and the, like they said, bundle of rights, or as is given, the concomitant rights which are given to the heterosexual couples. So when I start this off, I'd like to quote a case which is the Devdasan versus Union of India case, where they said mere inequality of treatment does not amount to discrimination and the object of the legislation must be considered. Here, like we have previously stated, the object of the legislation is to cover the social institution of marriage. We have not even proceeded to the concept of partners, to the concept of sexual orientation, or as was brought up by the respected Council of Petitioners, the concept of love. Those kind of concepts have not even been covered. We have only considered the concept of the social institution of marriage. Whether or not you should have a partner, like they said, is a personal autonomy, is the personal choice of a person, as was said in the Puttaswamy judgment, as was upheld thereafter, even in the Navtej Johar judgment. So this is very starkly different from the concept of marriage, and it should be noted, Your Lordship, that there was a very definite reason why, whilst the decriminalization of section 377 was done, no other rights were considered, because the current societal morality and the constitutional morality refuses to recognize it. Therefore, there are definite morals and laws that should be followed. There does exist a definite utopia to the situation that has been presented. However, how much is that valid, and how much does this honorable court consider mere allegations given to the current facts and circumstances of the world, of the society, and of our country of Indy? If all those things are not brought into play, then just assuming a right to be given will benefit everybody at large. It will not benefit. And like they said, it is not a small faction, it is a very large faction. If we are saying the rights will be given to them, but the rest of the public is going to suffer, then what, on basis of what are we weighing the rights? When the morality itself is going against, when the recognition itself is refused, the basis on which they try to proceed itself stands moot, because they are trying to say that decriminalization is the first step toward recognition. Whereas if a hypothetical situation be portrayed before this honorable court, if I were to hit someone which was previously illegal, has now been decriminalized, me hitting them does not become correct. It's merely said it is not punishable. Because there is a vast difference between allowing someone and promoting or propagating an act than just saying no, there is no punishment awarded for this particular act. And that is what should be given paramount amount of consideration, more than the utopia that is being created by the submissions given before this honorable bench. Lastly, Your Lordships, I'd like to quote a few cases that were given by the Honorable Supreme Court itself, wherein the right was restricted, and this was as stated by my co-counsel as well. In the case of A.K. Gopalan, like it was said before, it was held that the desires of a man need to be controlled and reconciled to match with the desires of others. So here we are portraying the rights and the duties of one person with the rights and the duties of the public at large. When you weigh these two, the needs of the many definitely outweigh the needs of the one. And when we are doing that, it is very, very, very necessary that we take the public good into account, especially when we talk about articles like 14 and 21, where the major basis is equality to everyone, separating one class by the way, this separation has been done them by themselves, because this separation was not brought about when the initial institution of marriage was done. So when this differentiation is done by was done by themselves, it cannot be said that these articles are in any manner being violated, or that their recognition would promote would help in promotion of their rights, whereas the immediate cause of it would be anarchy and unconstitutionality as a whole, because there is no precedent that exists which can establish that this recognition will do good to the public at large, because we are weighing the rights of a faction towards the right of the general public. And when we talk about health, when we talk about safety, when we talk about psychological development of children, all of these issues supersede, precede, and are much more important than mere recognition of rights. And like you said, Your Lordships, it is no more illegal to be in a relationship. So when the relationship is being established, like they said, there is a recognition that is required. They themselves are giving them recognition by being in that relationship, and they themselves are saying that that their right should be private. Why is the state intruding in their right? The state is not intruding in their right. Please be in a relationship. Why are you asking for the amendment before this honorable bench when you are saying the right is private of your own? Keep your rights, and we will keep our constitutional mandates which have been upheld for umpteen number of judgments for an umpteen number of years.
The LGBT persons are also part of the society.
Indeed, Your Lordships.
The relationship is in a way recognized by nothing illegal about having a relationship.
Indeed, Your Lordships.
So
that is exactly our contention.
Issued certificate of marriage.
Your Lordships.
There should be some regulation.
Your Lordship, that contention has not been explicitly made, because they are saying that their relationship is not being recognized.
They are saying it can be read down.
Indeed, Your Lordship.
Provision can be read down so as to include.
Your Lordships, when the concept is only based on the recognition of their union, they themselves as individuals, and they themselves are as a community are recognizing that union. But they are asking for the amendment of the constitution and of the regulations that have been established over a long period of time, without taking into account the aftermath of such amendments that are to be made. It is definitely a utopic world where everyone has their rights, where everyone is happy with whatever is going on. But how can we outweigh the need of the public at large when the faction just wants recognition, but this recognition has already been given to them with respect of that community and with respect respect of those two individuals. So at the face of it, the concept of recognition, because they are also a couple, is given by the community and is given by the individuals. However, this amendment is not a way of recognition. This amendment is just a precedent to anarchy that might befall if the amendment is so done as per their wants.
You are done?
Indeed, Your Lordships. The Council seeks permission to move towards a prayer of the case. Much obliged, Your Lordships. In light of the issues raised, arguments advanced, and the authorities cited, the Council seeks permission before this honourable bench to dismiss the petition or to pass any such order as they deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the Council for the Respondents shall duty bound forever pray. Much obliged, Your Lordships.
There is that the imbued laws are not violative of Article 14, but they haven't proved what is the objective there for the intelligible differentia. They have again and again said that it is not violative, but they haven't provided any single objective as to why we should consider that they are not violative. Coming to the first contention that the Special Marriage Act is just for intercaste marriages, if we read the objective of the very said act, Special Marriage Act, it says marriage in certain cases, and the definition of certain cases is up to the interpretation of this honourable court in the present case as well, and which can include the LGBTQIA community plus individuals to be get married in the Special Marriage Act, because the objective is for certain cases and not just intercaste marriages. If the intent was of just intercaste marriages, it would have been written down literally by the legislature, but that is what we are contending, that it is not written. Coming to the second point, they just want to save the registrar that they did not give the certificate, but they are not saving the state which they are representing in the case from the side of Respondent Counsel number 1. They have to show that why a state should not provide laws to these communities, but they have failed to do in doing so, because it is a social institution and the state is the one who regulates it, and they have been denying us the right to marry since the time immemorial, and thus we contend that that we should get those rights. Coming to the point of social norms and morality, they haven't explained as to why and what the morality in the present scenario means and what is the morality term includes in its ambit. And we come and say that the social norms are the norms which are set by the society themselves, and the society is welcoming them with the open arms, and we have seen the cases of Navjeet Singh Johar case, and in the case of Arun Kumar, where they have recognized the existence and recognize the status of couple, like two individuals can live in a live-in relationship of this community, and this shows that the society is changing, and even the judiciary is applying such rules and recognizing such couples in the society, and thus we say that that is the first step towards the recognition, and thus hereby we contend that they should be given the true remedy of such act, and they should be allowed to be married under such impugned laws, because such impugned acts and such laws which are violative should be read down in a manner and interpreted in a manner so as to they apply to any individual irrespective of their gender, sex or sexual orientation. Coming to the point of Nalsar case which the side opposition quoted, like it says every human right should be given to every individual irrespective of their sexual orientation, and human rights include right to marry of one's own choice, and this is what we contend for. This is what we have been contending so far, that love is love and every person should have a right of its own partner and choose their own partner and have a family. Coming to the next point as to AK Gopalan case. AK Gopalan case was overruled by the Maneka Gandhi case, which included the term due process of law, in which it stated that it should be based on reasonable and just, the law should be reasonable and just. But in the present scenario, the law is not just and reasonable because it violates the fundamental rights of the petitioners, that is Article 14, 15, 1 and 21 of the Constitution of Indy, and thus we contend that the impugned laws, to the extent they violate the rights of the petitioners, should be read down in a manner and should be held unconstitutional. Coming to the point of bullying, they are bullied because their parents are not given the recognition and the certificate of marriage and a tag of marriage as parents, and this is the main reason why they are being bullied. And thus we contend that if we recognize them in the society, if the judiciary recognizes them, then there would be the question of dignity would not be like the question of dignity would not arise, because now they are dignified and they have a place in the society, and the society would welcome them with their open arms, and this is what we contend for. And also Article 15(1)(c), which says that if India is signatory to the convention, then they should apply the laws of such conventions in the fundamental rights, and thus we contend that the UDHR and the other universal rights which provide that right to marry of one's own choice is given should be a fundamental right under Article 21, and it should include the LGBTQIA plus community individuals as well. Coming to the point of if the fitness of the lesbian mother which they challenge, fitness or if a person is fit or not for the adoption or surrogacy is always in question, be it heterosexual couple or homosexual or a single parent. That is the main essence of the adoption or surrogacy, that the parent should be fit, and in every case it is done. Why to discriminate between homosexual couples or heterosexual couples? Coming to the point of commercialization, your lordship, commercialization is banned by the Surrogacy Act, and also to ban that they have allowed close relatives for this process. And apart from this, there are proper guidelines to channel this, and the commercialization would not take place in any scenario. And why we are saying that? Because surrogacy is a safe process as well, which they have tried to manipulate, saying that no, it leads to very health issues. That is not the case. We have seen the ample of cases of surrogacies. We have seen heterosexual couple who are infertile or cannot reproduce, or they do not want to reproduce by the natural methods. They can they go for surrogacy even when if they cannot procreate. And thus we say that it would be the same scenario in each sense. Like they are dividing just the couples on basis of nothing, because a heterosexual couple can also get a child through surrogacy, and why should not a homosexual couple? And coming to the point, what is the cost of it? Greater good of public. Injustice to one is injustice to all. We have seen that in ample of cases, and we contend that a small fraction does not merely mean that we neglect their rights, because their fundamental rights are being violated. Fundamental rights of each and every individual is important, and in the present case there are a lot of people of this community existing in India, and we have given you ample of cases as to how it would lead to the extramarital affairs in a marriage, and how it would ruin marriages in a lot of cases, because people due to societal pressure marry person of opposite sex just for the societal pressure, and they still continue to have affairs outside the marriage with the same sex couple or any person of the just counsel seeks one more minute. Much obliged, your lordship. Your lordship, coming to the point of American survey, that is not at all applicable to India, because the laws and the norms and the mindset of the people of that country is totally different from India. The legal age for marriage is also totally different. We cannot compare India as to America, because the development rate is also different, and so many factors has to be considered. We are talking about India right now, and we have provided you that the tradition and custom also involves such practices in the sculptures of the Khajuraho temple in Madhya Pradesh, and also in Kama Sutra. They have established that this exists since time immemorial, and thus we contend that it should be allowed and the discrimination should not be done. Coming to the next contention, your lordship, that decriminalizing 377 was a step towards the recognition, and thus these impugned laws should be read down in a way, and they are violative, and they should be given the right to marry and adopt and surrogacy. Much obliged, your lordship. The council seeks permission to
the social institution of marriage and not the recognition of your respective partner. Therefore, when there is no intelligible differentiate, them differentiating themselves as a class or a different community of people solely based on their preferences is a prerogative of their own, which is completely immaterial as a question before this honorable court. Coming to the second contention that was given, where they said that Special Marriage Act refers to certain cases. Now, this concept of certain cases has not been explained anywhere. Therefore, simply saying that certain cases should include the concept of the LGBTQIA plus couples based on without the basis of any precedent before this honorable court is again a hypothetical question, and if it is not based on facts and circumstances, should not be considered by this honorable bench at all. Coming to the third thing, which was said that the councils only merely defended the registrar with respect to the registration of marriage and not the state. Your lordships, before, like with respect to marriages, the registrar of marriages is the representative of the state with respect to marriages, and therefore if we are defending the registrar, we are by extension defending the state, which should be taken into account because the registrar is the representative of the state. Coming to the next point, where they said that what is the current morality that has not been established? Well, the current morality was established when an umpteen number of times by counsel of both sides it was mentioned that the Navteej Johar case has decriminalized consensual sexual relations between persons of the same gender. That is the existing morality, where we say that the scenario is no longer punitive. However, saying that the current morality is going to include same-sex relations and same-sex marriages is nowhere mentioned even in the Navteej Johar judgment. So simply bringing it up just to prove a point or to show that it is the first step does not make it the first step, and that is just a hope that the Counsel for the Petitioners have portrayed before this honorable court. Coming to the next point, where they said that human rights should be given to everyone. Now indeed, yes, human rights should be given to everyone, and that is exactly what we are saying. Please give the human right of health, the human right of not staying in a state full of anarchy be given to everyone, and not simply the human right of being married to it. So your personal choice cannot supersede the greater good of others. So yes, give human rights to everyone. Let everyone be in a safe state, let everyone be healthy, and let everyone be happy. Coming to the next point, where they said A.K. Gopalan was overruled. No, A.K. Gopalan was not overruled. The mere definition given in the A.K. Gopalan case was expanded in the Maneka Gandhi case to include the principles of natural justice. And as we have established, the principle of natural justice is not violated, and hence the procedure established by law still stands and still should be taken into consideration. Coming to the next point, where they said where they said that the judicial recognition, if given by this honorable court, should be given, because that is how the bullying will stop. There is no mandate on the concept of bullying because it is based on constitutional and societal morality. So that is where the concept of bullying comes in. When they ask for judicial recognition, they are doing it without considering the aftermath of those persons and without considering how much of time will be taken into the implementation of this recognition, and taking into account the consideration of this amount of time, subjecting a large number of people to anarchy, to state of unhealth, is simply uncalled for and should not be granted by this honorable bench. And lastly, there was another topic that was brought about, where they said that homosexuals have been in India since time immemorial, and they said that the Khajuraho temple and the Kama Sutra allows for, have seen same-sex couples and sort of promote the same-sex couples. There is a much better reference from that time, which is Vedas, specifically the Rig Veda, wherein they have said if there is any consensual sexual relation between persons of the same gender, it is done without the consent of the parents, without the consent of anybody as a whole, and simply symbolizes the union of those two persons, which in this case has been allowed, as we have decriminalized section 377. Please have your union. It does not allow for the recognition or the concept of marriage to be included herein. And lastly, to conclude my arguments, I would like to say that they said that the American survey should not be applicable in India, but they are saying that the Universal Declaration of Human Rights, without consideration of anything, should be applied in India. If you are saying American survey is not applicable, that is where the UDHR was made a mandate, and when that happened, the American survey showed the effect that happened on such children being adopted. So if that study is not enough to show what will happen in case of the UDHR being applicable in a country, then I don't know what proofs can be given to suffice. Whereas allegations made by them solely rest on the concept of a prayer given before this honorable court, and we stand by the facts, the circumstances, and the statistics which have gone to show that a simple implementation or a minute implementation of one of the rights led to so many problems with respect to children, with respect to women as a whole. Much obliged, Your Lordship.